Riley vs. California, Fourth Amendment Search and Seizure by Hazel, Syke, and Gabby Owens. Who is David Riley? David Riley belonged to the Lincoln Park Gang of San Diego, California. On August 2, 2009, he and others opened fire on a rival gang member driving past them. The shooters then got into Riley's Oldsmobile and drove away. Before trial, Riley moved to suppress the evidence regarding his gang affiliation that had been acquired through his cell phone. However, his motion was denied. During the trial, a gang expert testified to Riley's membership in the Lincoln Park Gang, the rivalry between the gangs involved, and why the shooting could have been gang-related.
David Leon Riley was pulled over in San Diego, California on August 22, 2009 due to expired license plate tags. During the stop, the officer discovered that Riley's license was also expired. Due to both of these complications, a vehicle search is mandatory. As the officer was searching Riley's vehicle, he found illegal contraband hidden in his car. Riley was then detained and taken into custody where his personal belongings were confiscated while they ran a ballistics test on the two firearms that were found in his car. Riley's phone happened to be one of the items taken during his arrest. Law enforcement then took it upon themselves to search through his phone where they found videos and pictures of Riley holding up gang signs which tied him to the Lincoln Park Gang of San Diego, who were just involved with a drive-by shooting a few weeks prior. Riley was then tried with shooting of an occupant vehicle, attempt of murder, and assault with a semi-automatic firearm. The jury prosecuted Riley on all three counts and sentenced him to 15 years to life in prison if deemed guilty. The Fourth Amendment states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. In better terms, the Fourth Amendment prevents a violation of privacy by prohibiting any and all unlawful searches and seizures without a warrant. Diving deeper into the Fourth Amendment and its impact on vehicular searches, there must be a probable cause for any unwarranted search. The Fourth Amendment establishes that in cases having to do with on-person searches, any officer may conduct a pat-down of the driver or passenger during a lawful traffic stop. And in cases when the search is in someone's car, an officer may lawfully search any area of the vehicle in which the evidence might be found.
How does this pertain to the Fourth? Now, let's take a look at how the Fourth Amendment is involved in this case. Here is Lawrence Hurley touching on the subject.
Mr. Hurley, what did the court decide and what impact does it have?
So the court ruled on a unanimous vote that police officers in most situations need a warrant before they can search a cell phone when someone has just been arrested. And this was quite a big ruling because this issue had never been decided by the courts before, taking into account the unique nature of cell phones in the current age where everyone has one, everyone's carrying them around with them, they have a lot of personal information on the phone. So the court said that a cell phone is not the same as other things you might carry around on you that police generally are allowed to search without a warrant.
The Supreme Court ruled a unanimous vote for Riley in which law enforcement went beyond the boundaries of the Fourth Amendment search and seizure. David Riley is still serving 15 years to life due to his conviction with the same crimes he was tried for, which consists of shooting at an occupied vehicle, attempted murder, and assault with a semi-automatic firearm. These charges were proven through the ballistic test done at the two firearms found in his vehicle during the traffic stop.